Yeah! Well, now the gavel's calling. Let's get this session started. Hey, folks, grab a seat. It's time to get the scoop. Bakers in session, serving justice with a whoop. From sunny Cali courts to the heartland's dusty halls, we'll spin the yarns of trials big and small. Oh, Baker in session, tales old and brand new. Some make you laugh, some will leave you in a stew. Gavels dropping beats, witnesses take the stand. Join the fun, y'all, across this great land. Hey. Classic capers like OJ or that moonshine bust. Fresh headlines steaming hot, in Baker we trust. Murder in the Midwest, scams down south so sly. We'll break it down with grins, no need to cry. East Coast embezzlers, West Coast wild rides. Supreme Court showdowns where the big shots collide. From petty thefts to plots that twist and turn, Baker's got the stories that'll make you learn and burn. Oh, Baker in session, tales old and brand new. Some make you laugh, some will leave you in a stew. Gavels dropping beats, witnesses take the stand. Join the fun, y'all, across this great land. Famous folks in hot seats, underdogs who win. We'll cheer the verdicts, dive right in. Coast to coast adventures in the name of the law. Baker's here to share it without a single flaw. Hit subscribe, don't miss the legal ride. Baker in session where the laughs collide. Hey, how we roll.
Good and welcome to this special presentation of the Cosgrove late response to the mega motion filed by Attorney Better Rowe in the Aidan Turtleboy Kearney case. This is 26 pages that was, I believe, if we count the weekend, it's 8 days too late that they filed this, and it was filed with a wish to have more time because Cosy G, the man, the myth, the legend, had underestimated the amount of time he needed when he already got more time to write his mega motion reply. And because he had another case that he had to take care of in front of Judge Corrupt as well. I believe maybe I was wrong that Mr. Cosgrove only had one case because he's a special prosecutor called in to take care of the Aidan Turtleboy Kearney case. So I don't understand what other case he is having in front of Judge Corrupt that could take his time. But what do I know? It seems like, hey, if it flies, it flies. Shouldn't he have asked for an extension before he was 5 days late? I think it's technically 8 days because of the weekend, but I might be wrong. Yes, that's what. But again, it's Massachusetts. The law is the law is the law, and if you believe in justice. If one of my mods could share the link to Turtleboy's Defense Fund, because this is why we try and remind people that if you have the ability to help out a little bit, maybe consider helping Aidan out, because this is more BS from a BS trial, from BS witnesses who was BS intimidated. And Aidan yesterday talked about it on, I believe he talked about it on Billy Bush, that he was over 200K in the hole so far. So if one of the mods can share a link to the defense fund, and if anyone wants to consider it, it's there. Laurie, I think you're right. December 5th will most likely just be another uh, uh, your judgeship. I was I time motion. This is this is another ambush on the defense team because you are stealing the defense's time to be ready for the next hearing. And at the same time, this idiot is asking for more time. He has had plenty of time to do his job. He claims that, well, he needed to get some affidavits and he needed to do some stuff. You don't have anything else you need to do. Get your lazy, overpaid butt to work. As I said, he finally got his finger out of his exit port and started replying to this. Thank you, kid. And we're going to pin the link to the defense fund at the top of the chat. So if anyone wants to contribute to the Turtle Boy Defense Fund, please consider that, because Aidan is who we are trying to help right now, along with Kelsey Fitzsimmons. Both of them are being bomb rushed by Massachusetts' horrible justice system. And he didn't communicate with the defense at all. No, he didn't give a heads up like you would do and say, hey, I'm going to be late because this is going to take more time. So just to let you know, no, this is just ambush as always. When was this filed? Aidan was live last night. I believe it was sometime around 9 or 10 your time when he was all of a sudden got a text message. Oh, by the way, we got served a response from Cosgrove. So out of business hours, they were given this piece of paper. Well, these pieces of paper, because it's 26 pages of response. But we're going to look into it and see what's in it. Sorry if you needed to refresh from the moderation changes. Okay. What did I miss this time? I don't know. 11:30 last night was when Bradle. Yeah, sorry. I saw it later that Aidan got it, so I didn't know what time. It's my normal sleeping times. 11:45. I'm pretty sure it was closer to 10:30. Well, at after business hours. In Denmark, we have these electronic mailboxes where the government sends you all of your stuff, because then if you get served like me, I have to go to court Friday. They will send it in that one because they can then see I have opened that email, so they know if I don't show up, I have been notified and should be there, and they can then hold me in contempt for not showing up to court. They are not allowed to send out any messages after business hours, because we had a period where they would send everything Friday at 4 p.m. So everyone got it late on a Friday, and that's not okay, because then you can't call back and say, "Hey, I got this. I don't know what this is." So you would have 3 days where you might be afraid that, oh, I'm owing back taxes or something with my kids or something like that. So we actually have a rule that you can't, from the government, send anything to us after business hours, because there were so many people complaining that they got all of that on Fridays, because if it was shitty news and they didn't want people to call in and get angry, just send it on a Friday at 4 p.m. Turtleboy said it was 11:30. Thank you, Sue. Yeah, I don't. Again, I saw Aidan when I woke up this morning. He was still live, and that was, I woke up at around 12 o'clock. The government doesn't work on the weekends. It's the government. Do your government work on weekends? The judge should tell them to pound sand. Well, he's not going to do that. But let's get to it and do it. Commonwealth v. Aidan Timothy Kearney. This case is specially assigned to Judge Belesos. Commonwealth's memorandum in opposition to Attorney Bettero's affidavit in support of motion and associated submissions. And I want you to notice the tone of, I read the first page and a half. I want you to notice the tone. This is the state speaking. It's not a defense attorney. It's not a party in a civil suit. This is the state that you give all the power, all the money, who should be better than this. It's just what I'm going to say. That's my opinion. I believe when the public files something to you, they have to be proper. This sounds kind of like going on TwitSweat right now and find out with all of those girls who are backstabbing each other right now on the TwitSweat. It kind of sounds like this. This is the gist I get when I read this. Well, the government never works, but they have to be at the job site until Friday at 4 o'clock. They are always rude. Well, they shouldn't be. They should be communicating in a clear, concise, professional manner. But let's read this. The defendant has filed a group of documents supporting an unfiled motion or motions. Most notably, what is effectively a motion for reconsideration of the denial in large part of the defendant's previously filed and decided McCarthy/Odell motion to dismiss. The present defense documents include Attorney Mark A. Betterow. I don't know why I want him to be Anthony. Maybe it's Mark Anthony. Affidavit in support of motion 87 pp. Various exhibits about 55, and a memorandum of law in support of motion to dismiss the indictments. Functionally, it is difficult to distinguish the Betterow affidavit from a memorandum of law, although it also serves the function of informing the court of what unfiled motions it's supporting. Betterow affidavit. In brief, the defense seeks outright dismissal of the pending indictments pursuant to Commonwealth v. Odell, or alternately, an evidentiary hearing in support of that aim. Dismissal of the indictments for the Commonwealth's alleged failures in providing discovery and disqualification of Special Prosecutor Kenneth Mello. After setting forth these aims, the Betterow affidavit first launches into a section entitled Background, which is essentially a hagiographic. I have never heard that word before. Portrait of the defendant as a crusading, heroic journalist, fearlessly pursuing the truth, exposing the falsehood of the Commonwealth's witnesses in the Karen Read case, laying bare the corruption of local and state police, and bravely resisting the attempts of the forces of evil, aka the Norfolk County District Attorney's Office, to deter him in his courageous and never-ending battle for truth, justice, and the First Amendment. This is where I think you can't write it that way when you are the state. This is a pity motion. Oh, he's putting his client in a good light, and he's trying to make him to a saint. I don't give a fuck that you don't like Aidan Kearney. The state doesn't answer anything like this. Hagiographic writing is saint writing. Thank you, Charlie Rachel. But how can the state have someone write like this? This is how Kate Peter and Lindsay Gattani is communicating on the Twit Twat, not with the $5 words, just with $1, well, EBT card words. But this is, oh, Betterow is dumb. He's saying mean things and he's trying to make his client look good. That's his fucking job. This is stupid. Yes, it is a precise word, but rude in context. Yes, because of course, this is what we always talk about when we cover cases. A defense attorney's job is to make his client look good, no matter if he stabulated a bus full of handicapped children or he's innocent. His job is always to try and make him look better than he is. But you don't go and get upset and then write stuff like this. I'm sorry, that's unprofessional. Exactly, Laura Marie. It's unprofessional. That's why he cost money. No, he cost money because no one else wanted to touch this case. How does he get away with filing this stuff so late? Oh, wait, I know. It's the Commonwealth. They can do what they want. Sickening. Exactly. It's the same as why can Jen McCabe lie on the stand? Because she's lying in a way the state wants her to lie. So there's no perjury charges. It's only perjury if you lie in a way the state doesn't like. In reading Betterow's Ecominus, again, I'm sorry, this is $10 words. Encomius, I think it's encomius miums, to Saint Kearney. This is again such a demeaning way of writing in a brief. This should be thrown out just for the language alone. This is something you see the weirdos in the Hills case filing against each other. This is the state, y'all. One is irresistibly reminded of Oscar Wilde's comment on the death of Little Nell, the virtuous child in Charles Dickens' The Old Curiosity Shop. One must have a heart of stone not to laugh. Again, very professional to claim that you need to laugh at a court filing. Something that maybe Mark Randazza could write, but not in a court filing. Thank you, Jen Toxic, for 2 months. I meant that's why Betterow makes the big bucks. Okay, yeah, because I thought Cosgrove, he does it because no one else want to do it. Good heavens, it sounds like high school girls on Facebook. Exactly. Using 100-year-old references. Well, he's going back to what he read in school when it was brand new. I like to see a judge just say enough is enough and put a stop to this madness with this case. Broken-hearted, you and me both. And encomium is a speech usually to highly praise someone, like the prosaic version of an ode. Then use those words. I know what prosaic means. Aidan's new donors is going to be named Betterow Bucks. Well, again, if you want to contribute to his defense fund, the link is in the top of the chat. The Commonwealth has had occasion to respond to such drivel. Again, why do you need to have this loaded language? In the past, and with some reluctance now does so again. Rather than reinvent the wheel, it quotes liberally from its response to the defendant's previous motion to dismiss. Okay, so you can just, because it's just drivel, you can just use what you already did. Then why have you wasted so much time, you old fart? Defendant Kearney is a self-employed supporting himself via a variety of internet presentations, appearing on such outlets as YouTube, Facebook, X. He broadcasts quite frequently, at least 4 times a week, and has monetized his productions in various ways, including selling subscriptions, begging online for contributions. I have never, ever heard Aidan beg. I've never heard that. I've heard him say that if you want a turtle chat read, you have to pay, I believe it's $5 or something on. That's not begging. Again, why do you need this loaded language? It's not like it's twisted tragedies we're talking about. By the way, remember to support her party bus. She has a birthday coming up, or had a birthday. Don't give her any money. Selling T-shirts, etc. He attempts to present himself to the viewing public much as he seeks to portray himself to this court as an investigative journalist, reporting matters of public concern, who often breaks story by conducting investigations into matters neglected by law enforcement before viewers' very eyes live on the air. The crusading journalist pose is supplemented by assertions of virtuous moral outrage, fearlessness in the face of opposition, and crass vulgarity, as seen, for example, in the opening to his YouTube shows, which begins with an extensive repeated chant of, "I am going to F you up." Is he still using that? The indictment against Kearney at issue in the defendant's original motion to dismiss largely, perhaps entirely, grow out of his activities connected to the Karen Read case and its witnesses. Footnote. A subsequent set of indictments against Mr. Kearney named a former paramour turned informant for the Commonwealth, Lindsay Cartooney, as an alleged victim. Those indictments has since been dismissed by the Norfolk District Attorney's Office, and she might very soon be a witness for an informant for the defense. Let's hope so. Reed has pled not guilty to charges of second-degree murder, manslaughter while operating under the influence and leaving the scene of a motor vehicle accident after personal injury that resulted in death. As recently summarized in the press, the Commonwealth alleged that Reed back to legs. I don't know why this is in here. All of this has been thrown out. Prosecutors opposed motion to dismiss charges against Karen Read, call allegations of evidence tampering baseless. Boston Globe. I don't know why they still have this after the case was won. The defense claims that Read was framed and that O'Keefe entered the house owned at the time by fellow Boston officer, where he was fatally beaten in the basement and possibly attacked by a German Shepherd before his body was planted on the front lawn. I don't know why this is in this hearing. At some point early in the Karen Read prosecution, on or about April of 23, Kearney made her the subject of some of his online presentations, apparently drawing a favorable audience response. One person who took note was Natalie Vivek Berschneider, who had attended Bentley College with Reed from 98 to 2022 and was now living in California. That's Natalie the German. In February 22, Vivek saw news articles about Karen's arrest stemming from the death of John O'Keefe, prompting her to contact Reed and offer support. The two women began an ongoing series of conversations covering a number of topics, among them Reed's alleged innocence, not alleged, proven in court. Red sent Vivek pictures of Colon, Albert, and suggested that he and O'Keefe shared mutual animosity. In April 23, Vivek spoke with a Facebook supporter of Reed's who told her she had a friend, Kearney, who would be willing to cover Karen Reed's story. Vivek asked Reed if she would be interested, and she was. To facilitate communications about the case, Reed instructed Vivek to download a messaging app, Signal, which auto-delete messages after a certain period, only if you set it to it. I also have Signal, and I am not a criminal. Is that footnote about fake victim there to try and disparage any info Aidan collects from her? No. Seems like it, since I don't see why it would be there and say informant. Because she's mentioned as an informant in Better Rose Mega Motion. That's why it's mentioned there. I will bet you that Cosgrove have no idea that Aidan's team is in some form of contact with Cartooney. Vivek assumed the role of go-between between Reed and Kearney, with Reed sending her information and pictures and Natalie pasting it into text messages for Kearney. Vivek stated that these text messages included information regarding witnesses, the home address of Trooper Michael Proctor, pictures of witnesses, autopsy photographs, motions filed by her attorneys, police reports, and photographs taken by the Massachusetts State Police Crime Scene Service section. In short, Reed passed along through Vivek everything Kearney would need to act as a press agent for Karen Reed while feigning the role of a crusading investigative reporter. Reed would sometimes point out mistakes in Kearney's blog presentations to Vivek. For his part, Kearney would ask questions about court paperwork, which Vivek would forward to Reed, who would respond to her. I don't know why this is in here. This is to do with the allegations that they cooperated to intimidate the witnesses. I, we read this before for about the grand jury indictments, didn't we? Reed and Kearney took pains to conceal their relationship from the public. She would sometimes send him information but tell him he could not put it on the air, typically because it was information that had come to her through discovery but was not public. Inferably, use of the information would alert this court and an observant follower of Kearney's, if such exists, that she was feeding him information. And an observant follower of Kearney's. There's a lot of you who are very observant followers of Kearney's, especially during the Kearney case. Why do you have to be demeaning in your motions? That she was feeding him information. It is also clear that Reed enlisted the cooperation of counsel in coordinating her information dumps to Kearney. Brian Tully's testimony provides a telling example. In mid-May, Kearney sent Wiebeck a picture of himself wearing a t-shirt depicting a Google search bar with the phrase, "How long to die in the cold?" I believe that says, "How long to die in the cold?" A reference to a piece of evidence in Commonwealth we read. Wiebeck responded she will ask Reed if he can wear it to court. Wiebeck later tells Kearney, quote, "It's okay to wear the t-shirt, not short, t-shirt. How long to die in the cold? I got the okay," end quote. Kearney responded, "You asked Alan," an apparent reference to one of Reed's attorneys, Alan Jackson. Wiebeck responded, she replied, "Absolutely." Kearney wore the t-shirt in the July 25th, 2023 court date. And I don't know if this is redacted or it's an error. Does it go to page 4? Well, it's an error because page 4 is there. In early June of 2023, the two women had a falling out. Wiebeck had provided some encouragement and advice to Kearney over a proposed documentary. Upon learning of it, Reed became angry. An argument ensued, and the two women ceased to speak to one another. Wiebeck was aware, however, that Reed also communicated with Kearney through a John Silvera, and Wiebeck herself had provided Reed with Kearney's Signal username so she could contact him directly. Grand jury summonses issued to Revison requesting call details records for two of Kearney's phone numbers and the phone number Wiebeck provided investigators for Reed. The resulting record showed 189 phone calls between those numbers, totaling over 40 hours. Kearney continued to lie to the public about his cozy relationship with Reed, denying in an August 29, 2023 video that he was communicating with her or her lawyers. Obviously, the telephone was not the exclusive means of communication, as the two was also communicating, for example, through the Signal app. I don't know why this is here. This is motions filed to have. This must be something that he used to file back when they're still trying to claim that they work together to intimidate the witnesses. So wearing a t-shirt is intimidation. It's all the intimidation. Why is there a capital I in the middle of a word shirt? I can't. Well, there's also the double spaces right here. Of course, I can't draw in this document. There's the double spaces right here that I know someone used a dash, but to me, it's always just this is AI. Still fighting old battles. Yes, it's the good old. He is using the motions they used back when they tried to get them on colluding to intimidate witnesses, which they are still trying to do, because that's why Kearney can't get her phones back. But he's using that to combat the mega motion, which just seems odd to me. The defense has developed in its first retrial a tedious, tendentiously previewed by Kearney's statement. Defense, as it developed in the first Kearney retrial, as tendentiously previewed by Kearney's statements and actions, and as it unfolded in court, was something a murder on the Orient Express defense. Everyone in the O'Keefe home on the night in question, as well as the investigating officers and others, either murdered John O'Keefe or was complicit in the cover-up and framing of Reed. Nothing of this was said in court. Who was innocent? As the grand jury could have concluded from the evidence before it in pushing this theory, Kearney attacked virtually every prosecution witness, including all people present in the house that evening. So this has to do with, this must be something in connection to what they filed in the grand jury, where they tried to get indictments for them collaborating to intimidate witnesses. What does this have to do with the mega motion? As well as certain of their family members. He also savaged O'Keefe's family members for their support of the Reed prosecution. In addition to his verbal attacks, the defendant harassed many of the witnesses by means of what he called a rolling rally. Again, he didn't intimidate or harass them. I believe you have a First Amendment that gives you that right. Gathering a caravan of his followers to drive Syriatim, I don't know, to the homes of the witnesses, where he denounced and taunted them via a megaphone, often exhorting them to tell the truth, which the witnesses understood as an accusation that they were liars. Well, we now know, thank you, Queen of Hearts, for becoming a member. We now know that at least Carrie Roberts and Jen McCabe are liars. So tell the truth. How is that intimidating witnesses? Seriously, someone needs to do a wellness check on Cosgrove. He clearly isn't okay. No, I don't know what this has to do with battling what he claimed in the beginning. Well, I got this from Dave, who is somewhere near Detroit. I didn't even know what sport they're playing. Yeah, I hope good old Bukaki doesn't have to read this, because the words are really hard today. I believe that it was She's Like Texas. She has been an absolute monster with gifting memberships on me and Will DeClare's channel. Absolutely a monster. Thank you so much. Just sounds like something Krusty would say, like all of it. Well, Krusty, this is the thing. What they just claimed that Karen and Aidan did is exactly the same that Krusty and the Commonwealth did, because they gave Krusty special access. So Krusty could get their story out there. They are no holier than thou, as they claim they are. Krusty is working as an influence agent. I am 100. Have I proved? No. This is my absolute speculation. But Krusty is working as an influence agent for the Commonwealth, and a reporter and an informant of what the hell she's doing other than that. But she is helping them get the story out they want out. She was the only one who could get all the good scoops. Her and Plevin had special access doing, especially the first trial. Plevin had stuff that no one else had, and Krusty had stuff no one else had. Stuff that could only come from the Commonwealth. And now they're claiming it's not illegal for Karen Reed to talk to a journalist. It's not illegal to talk to a journalist who is in favor of your story. Aidan doesn't need to tell anyone watching, I am pro Karen Reed and I am in contact with Karen Reed. That's for his own, it's his own decision. You can then watch him and 2 years later say, oh, he had special access to Karen Reed. I'm so mad. I will never watch him again. There's nothing untoward for someone to talk to a journalist who promised them a good press coverage. I was in politics. You learn very early on. You talk to a journalist when you have a little bit of dirt on someone else, because when the dirt comes at you, they owe you a favor because you gave them a scoop somewhere before. You cultivate these relationships. Just look at Sue from Boston. She is sucking the butt of the Mayor Wu all the time on the internet because she wants the special access. There's nothing untoward in any of this, but they paint it as it's shady that she's in talk with a journalist. Journalist does stuff for special access all the time. How do you think TMC journals get special access to all the star stories? What? Yeah, the DA's office has special access to the local media. The local media never followed up on where is the ring camera video we were promised was there. I would have, if I had been a journalist, kind of like I said yesterday, someone hurt my integrity, and I don't like that. They didn't care because, fuck it. Argument. Having previously brought and fully litigated a McCarthy-Odell motion, the defendant has no right to bring a renewed attack on grand jury proceedings already upheld by this court. Arguments he's previously raised has been considered and decided and are settled. Arguments that he failed to raise but could have are waived. On February 14th, the defendant filed his McCarthy-Odell motion to dismiss indictments for lack of probable cause and for the prosecution's impairment of the integrity of the grand jury with misrepresentations of fact and law. At the time he did so, the Commonwealth had provided in discovery to the defendant all of the grand jury minutes. Among other things, he thereby necessarily had full and complete knowledge of the following: that the grand jury heard that Special Prosecutor Mello ultimately did not ask the grand jury to return an indictment against Kearney for illegal wiretapping Mr. Scanlon. All of the testimony of all grand jury witnesses, including Detective Lieutenant Tully. All of the instructions given or not given to a grand jury by Mr. Mello, and all questions and comments made by him. All of the excerpts of Kearney's online media presentations introduced in evidence and how they were identified to on the thumb drives introduced as grand jury exhibits. Kearney originally told this court that the prosecutor impaired the integrity of the grand jury by misrepresenting facts and law, soliciting opinion, and distorting the state of the evidence by selective omissions. He specifically argued that Mr. Mello's instructions to the grand jury was deficient, and that he elicited improper opinion and hearsay. However, he did not bother to raise any argument concerning the absence of a wiretapping indictment alleging that Scanlon was a victim, and neither did he complain about the accuracy, completeness, editing, or titling of the video excerpts introduced as exhibits. Undersigned counsel filed a responsive memorandum, henceforth Response 1, addressing Kearney's arguments on March 5th. On May 19th, having the benefit of both parties' memoranda, copies of the grand jury minutes, and copies of the online excerpts played for the grand jury by the Commonwealth, the court, Doolin, issued a comprehensive decision allowing the motion in part, dismissing 6 indictments as presenting insufficient evidence, primarily those that named troopers as victims, but otherwise denying it. Neither party moved for reconsideration. Neither party sought interlocutory appeal. Now the defendant wants to do it all over again. Writing on Kearney's behalf, Betterow has made the same arguments, having adduced various examples of alleged sins committed by Mr. Mello, some the same as presented by Attorney Bradel in the first motion to dismiss. He plucks a few different examples, but all of them were readily available in support of the defendant's position in round 1. As one justice of this cause has aptly put it, a motion is not a dry run or a dress rehearsal to come back once an adverse ruling is obtained to try and do it all over again. Commonwealth v. Pagan. To be sure, a judge may permit a motion that has been heard and denied to be renewed with substantial justice required, when substantial justice requires. Emphasis added. Such instances should be rare, however, lest, as said in a different context, judges would become Penelopes forever engaged in unraveling the webs they wove. Commonwealth v. Safrian. Get some real names. Quoting Elhan J. in Jorgensen v. York Icemark. Renewal, however, is typically appropriate where new or additional grounds are alleged which could not reasonably have been known when the motion was originally filed, like all the Rule 14 violations you had. Reporter's notes to Massachusetts criminal paragraph. Massachusetts R. Crim P. 13 emphasized added, in the Superior Court, a motion for reconsideration shall be based on newly discovered evidence that could not be discovered through the exercise of due diligence before the original motion was filed. A change of relevant law or a particularly undemonstrable error in the original ruling and decision. A motion for reconsideration shall otherwise raise no new grounds for relief not raised in the original motion or opposition and shall not reiterate previously advanced arguments. Superior Court Rule 9D. Motions for reconsideration. The defendant's motion for reconsideration flouts each and every one of these three prerequisites, which may explain why he shrinks from honestly labeling it as a motion for reconsideration. Another attack on Bettero's morals and call him dishonest. In his initial motion, the defendant did not attack, as he now does, any of the video evidence offered by the Commonwealth. Maybe that was because they didn't have it. They didn't know that there was Krusty the Clown who had given them and edited the video evidence. That's why you didn't turn it over in time. That's why you had a Rule 14 violation that the judge closed its eyes to. For his present motion for reconsideration, he now claims that the prosecutor and Detective Tully deceived the grand jury by grouping videos the Commonwealth offered as evidence of intent on a folder on the thumb drive exhibit labeled as intent, showing edited clips that allegedly deprived the grand jury of viewing Kearney's actually full episodes, many well over 2 hours long. And 3, assigning titles to the edited clips that did not match the titles Kearney assigned the full episodes. Although, as the Commonwealth will shortly develop, these arguments has been entirely waived by their omission from the first motion to dismiss. It first stoops to briefly address the substance of Kearney's newly raised claims concerning the videos. Tully never testified that Kearney created the thumb drive folder labeled intent, into which Tully placed videos showing Kearney's intent, and no reasonable juror would have drawn such an implausible inference. Moreover, the jurors had available for viewing the video clips themselves and could view them and draw their own inference as to Kearney's intent. Minor detail. You call it intent. The grand jury looks at it and says, oh, this thumbnail file is showing intent. That's what a normal person would look at it and say, oh, the file says intent. This must be showing that Kearney had intent. Why didn't you label it video clips? Why did you label it intent? Yeah, he labeled the folder intent, guilty. In court in Denmark, when we watch Cellbrite reports, we will have two, and the defense, the prosecution always tries to use one of them, which is the police working document. So the police will see a video of someone driving a car crazy and write, this is where suspect number 1 breaks the law. That will be out in the margin because that's for the prosecution, so they know, okay, I have to show this clip. And they will always, by mistake, put that one on the big screen we are watching it. And then the defense will say, objection, you can't have the opinion of an officer written. It's for the court to find the evidence. And they, oh yeah, sorry, I forgot. I got the other one here. And they do it every single time because they want us to know this is subject number 1 breaking the law. By writing intent on a folder instead of evidence A, you have already implied that what you're going to see in here is showing that he had intent. It's, yeah. I bet a ham sandwich, they kicked the can again December 5th. I think that ham sandwich could be upgraded to a BLT with grape juice jelly. 2. Counsel use of the term edited to describe the clips is artfully and falsely implying that the content was somehow modified or distorted. Where that's so, one might expect the 88-page affidavit to offer examples of these edits, but there are none. And that is because the edits consist entirely of exact clips of relevant content broadcast by Kearney. The only editing is selection. So take it out of context, which would be editing the content. The appropriate course the appropriate course according to counsel would have been to show the entire episode for each show, or by Mr. Kearney's count, over 50 hours of content, pre-sindering from any questions as to whether subjecting a grand jury to such an extended dose of Kearney video would have violated the constitutional prohibit against cruel and unusual punishment. I hope Betterow is writing a letter right now demanding this asshole to get slammed by the judge. Remember how mad Bev got at AJ if he just had a little bit of snark? This is a defendant you are trying a case against, and you're sitting and calling his videos cruel and unusual punishment. How can you have anyone working for you who cannot be professional? You lazy old fart. First of all, you're 5 days late. Second of all, you sound like the girls going at each other right now on the Twitch thread. This is like listening to one of the spaces that happens where people are way too into who is banging who is not banging who. You are a professional. You are paid an insane amount of taxpayer money to do a job that you cannot do. And you put shit like this into a court filing. This is, I don't know if any lawyers are here, but how the hell can you write this as the state? If it had been Mark Rendasa, fine. I read one yesterday, found it funny as hell. This is the state. You have the power. You are the one indicting this guy. And you're making snark about Mr. Kearney's content. Funny thing, he still pulls 7,000 people even when he doesn't really have any content. So a lot of people don't find it cruel and unusual punishment. But your old ass who cut all of these bites out, because as you stated yourself, most of these streams are over 2 hours long. You can cut bits out where I might reply to chat and say, Dedra, I hope I said I hope the new judge calls out Cossie for this BS. And you can just cut that where I say, I hope the judge calls Cosgrove out for this BS. Then I said it. You don't know if it's a super chat, it's a turtle chat. Whatever context people are saying it. It could be a reply to something that happened an hour before where you are making a snarky little comment about something that happened. It happens a lot on our presentations, especially the late night presentations, where we will get something from the chat or someone have said something extremely stupid somewhere and we reply to it with a little bit of snark. You should do better. If you can grab his motion for late acceptance, it's literally, sorry, I just took too long and I had other stuff to do. Yeah, it's just, I need more time. I underestimated how lazy I was. Such a course would have inserted confusing and irrelevant material, and doubtless would have generated additional defense arguments that Kearney was prejudiced because the Commonwealth presented evidence of other conduct for which it did not specifically request indictments. If one were to seriously entertain the defense, play the whole video argument, a useful way of thinking about it would be by analogy of the trial doctrine of verbal completeness, which holds that where the Commonwealth plays into the evidence passages from a defendant's statement that it believes supports the charge, the defense may then put in such contemporaneous evidence from the same statement which contradict, modify, or otherwise throw lights on the prosecution's passages. The rule of is the rule is exhaustively discussed in Commonwealth v. Watson. In the context of admission of documents, defendant has insisted that either the whole document or no part of it was competent. There is no such rule. Quoting United States v. Dennis, of course, the standards of a grand jury presentation are less exacting than a trial's. Yeah, because the defense have no say in it. A grand jury is not bound by the rules of evidence that hold a trial. No, and that's why you get away with it. The grand jury hardly could have been misled by the titles Lieutenant Tully used to identify the excerpt he played for them. Consider the specific example which the defense singles out: misnamed or misleading episodes. Those titled by Tully as "Trying to Destroy Colin Albert's Life," "Life as Normal is Over," and "Impromptu Live 8/7/23." "Albert Should Be Afraid," "Bedrow Affidavit," blah, blah, blah. All of those titles were taken from Kearney's exact words, which the grand jury saw and heard him speak as the YouTube clips was played, and which the court has as exhibits at the defendant's previous Mercado Del motion to dismiss. In Trying to Destroy Colin Albert's Life, Kearney begins by musing about whether Colin's aunt Jill Daniels, whose photograph he displays, has a crush on him, a proposition he modestly, though at first, a proposition that he modestly thought at first to be ridiculous. After asking his viewers to view in on this important topic, he opines that it's wild because I'm like trying to put her, like godson/nephew, in jail, and like kind of like, you use like too much, Aidan, destroy their life, but she also likes me. Like what? Too much like in that sentence. Two comments. Daniels is not a witness in the Reed case, but is a relative of a witness. Kearney considers her fair game for humiliation. Everyone is fair game for humiliation. Second, Kearney explicitly states the goal of his behavior with respect to Colin is to destroy his life. Jesus Christ. If there was any, it continued. In Life as Normal is Over, Kearney shares the screen with a photograph one of his acolytes. What the hell? Is he a warlock? Has snapped of Chris Albert when he was at what? In Life as Normal is Over, Kearney shares the screen with a photograph one of his acolytes has snapped of Chris Albert when he was at. You forgot to put the rest of the sentence in, you idiot. As the Commonwealth explained to this court in the previous go-round, in episode 598, Life is Over Now, Kearney taunts Albert, suggesting that he will never be able to go anywhere in peace because there are turtle riders everywhere who will harass him and photograph him wherever he goes. It's only going to get worse from here. Although Chris Albert didn't personally kill John O'Keefe, he raised someone who did it and was helping to covering it up. He adds, "Chris, I know where you guys were today. You all were in Agawam, weren't you? I got pictures of you in my cell phone. I got people sending me pictures. You guys were at some sort of little league thing in Agawam. Albert, McCabe's, all you people were there. So like just know that there will be no Life as Normal is Over." In Albert Should Be Afraid, Kearney assures his viewers that they have nothing to fear from the same Albert whom he routinely accuses of being implicated in a murder. The jury saw and heard Kearney conclude, "I'm certainly not afraid of Brian Albert or Colin Albert or any of these punks. They're afraid of me. They should be. I would be if I were them." If there was any prejudice to the defendant, Kearney himself was the author of it, damned not by sinister manipulation by the Commonwealth, but out of his own mouth. Talking about Jill Daniels, the horse-faced lady, being in love with him, I let me try and recreate how Aidan probably looked. It's a joke. It is a joke. It's a joke. Don't you get that? Pedro now has in print from the horse's mouth just how corrupt the Commonwealth is. Yes. Free speech is whatever the Commonwealth let you say, essentially. Exactly. And by saying that it's weird that she's into him because he's destroying his her nephew's life. There's something called online bluster, where you just say a lot of things and you're a tough guy. Kind of like when Colon Albert is drinking his girly drinks and talking about stepping up and fighting everyone, even though that guy goes to church twice on Sundays, once every night, kisses his mom goodnight every time he comes home, never misses one time, and has never been in a fight in his entire life. And I have a slightly used Brooklyn Bridge that you can buy at scrap price value. All of this is retarded in the literal word of the use of the word. This is so dumb. Reading this hurts my IQ. All of the above examples, chosen and singled out not by the Commonwealth, but by the defendant himself via the Betterow affidavit, are illustrative of the truth of Lieutenant Tully's statement that he named the videos to accurately describe their content, often using the exact relevant phrases spoken by the defendant. Didn't they complain that they claimed that the clips was taken from YouTube presentations that had that name? That's a totally different argument than what Cosgrove is responding to here. I believe that the argument Betterow made was Tully took episode 298 and said, well, this is called I'm going to fuck up Colin's life. So when the grand jury saw that, they believed that episode 298 was called I'm going to fuck up Colin's life. No, you're just finding the statement, I'm going to fuck up Colin's life in episode 298. That's what the argument was. Can someone explain to me how Cox do the right thing isn't witness intimidation? That is because he's not a cop. You know how that is. Didn't Cosgrove say no titles were changed? Yes. And this is the same argument he's making. He's saying these clips are actually, the titles on them are provided by Aidan themselves. But now it's because it's just to describe what's in them. But still, it's kind of like putting a folder called intent. If you call episode 298, kind of like my Unity streams, they have like a small, I always just number them out my ass. I don't know what number we are at, but I'll call them Cox is not a cop, for instance. I might in that episode talk about how I dislike Grant Smith-Ellis. If that was going to be used against me in the court of law and they claimed Unity 22, Grant Smith-Ellis is a stinking pile of weed water. Just because I said it halfway through the statement, halfway through the presentation. That's not how it works, brother. The episode is called Cox is not a cop. Again, you are subliminally sending signals to the jury. And that's what Betterow talked about. He's not talking about what Aidan said in the clips. He's talking about that Tully used it as the headline for the clips to try and imply this is how it was presented on the tubes. Also, some of Tully's titles for excerpts were far more anodyne than the Kearney titles for the full episodes from which they were taken. To pose two rhetorical questions, if Tully's purpose was to use the excerpt titles to inflame the grand jury, would he really title the excerpts from episode 580, Elizabeth Proctor, dumbest wife ever? Oh shit, I forgot to put it back on the screen. Well, fuck you, Elizabeth Proctor. Brian Albert's opposition motion. The bland call to Elizabeth Proctor. Would he have toned down Kearney's drunken lardo? Michael Morrissey declares war on turtle riders to response to D.A. Morrissey's statement. Yes, this is court documents now. But the court need not wade into any of the defendant's contentions about titling of the excerpt because the defendant has waived the argument, failing to make it in his original McCarthy-Odell motion to dismiss. At the time he filed that motion, he obviously had available to him the full episode names that this time around he has lovingly memorialized in a three-page chart, Bedero affidavit. He had all the relevant grand jury transcripts containing each and every word of Lieutenant Tully's that he now calls to the court's attention, including all of the titles designating the clips played for the jury, which he previously ignored but now excoriates. He had copies of the grand jury's exhibits, including each and every video exhibit played for the grand jury that he now references. No one knew better than the defendant himself what he had titled his original episodes, and that they were lengthy, often well over 2 hours in length. It could not possibly have escaped his attention that the Commonwealth played not the full videos but pertinent excerpts, that the Commonwealth placed some of those excerpts in an electronic folder designated intent, which the defendant obviously knew he did not create, and that the names of the excerpts typically corresponded to their content, not to the titles he himself had given the full episodes. So you are admitting that Tully changed the names of the episodes, just like Bedero said. Nobody was better situated to make these observations than the defendant himself. Finally, even straining Charity to the point of believing Kearney was oblivious to the obvious at the time he filed his McCarthy-Odell motion, the Commonwealth opposition to that motion clearly should have alerted him to the issue in time to raise it in an oral argument before Judge Drulin. Attorney Bedero correctly surmises that undersigned counsel had been unaware that the excerpt title came from Tully, not Kearney, relying as undersigned counsel did on the exhibits introduced before the grand jury. So even you got fooled by Tully. Idiot. However, for whatever reason, undersigned counsel nevertheless did notice one retitling and scrupulously called it to the attention of the court. In discussing the video excerpt confronting Jennifer McCabe at a lacrosse game, undersigned counsel stated that apparently the title was assigned by the Commonwealth. The video comes from a Turtleboy live broadcast entitled Asking Jennifer McCabe That Question. Does she know the answer? And now we get to the crusty panty. Yeah, he's gonna just rely on it and said you filed a motion to dismiss before, you don't get a second bite of the apple, even though we didn't turn over all of the evidence, and you know that because I was dragging my feet for I believe 6 months to turn over Rule 14 material. Krusty Panty's involvement as an informant in the investigation of Kearney's alleged crimes provided no substantial basis for reconsideration of this court's prior denial of the defendant's McCarthy-Odell motion. Kearney acknowledged in passing the existence of his prior motion to dismiss, but asserts that he filed it without access to undisclosed evidence, which he claims was important. Yes, all of the Rule 14 material you didn't turn over, and when you turned it over, you didn't turn it over anyway. But now you're claiming that you didn't turn anything over and there was nothing of substance in it. Isn't that wonderful? The defense designate two such pieces of evidence. First, communications between Miss Peters, Mr. Mello, and Tully, which was critical and, if disclosed promptly, would have been included in support of the defense's first motion to dismiss. And second, the previous discussed presentation to the grand jury for excerpts from Kearney's broadcast that was labeled by Tully. The defense claims that it learned of this for the first time on September 4th, 2025. As fully demonstrated above, this contention is risible. I'm learning a lot of new words today. It is true, however, that since the previous defense motion to dismiss, the defense has acquired communications among Special Prosecutor Mello, Tully, and Miss Peters, and so has new evidence. That being undisputed, the remaining legal question for this court is whether the significance of that evidence is such that substantial justice, Massachusetts Law 13A5, should dictate an undoing of Judge Drulin's previous denial of the defense motion to dismiss. It should not. Of course you say that. There is a factual dispute that the court should resolve. The defendant paints Miss Peters as a member of the prosecution team. Indeed, the dominant player to whom Special Prosecutor Mello outsourced investigative work. Footnote. On the one hand, the defense is highly critical of the Commonwealth as ignorant or dismissive of Peters' woeful credibility. On the other, it never fails to abduce the slightest boast by Miss Peters as to her own importance to the investigation as credible. Well, you do the same because you take everything out of context as well, my good sir. Where was that footnote? It was here. Per Betterow, Mello was supposedly aware that she edited Mr. Kearney's content with her own editorial slant and bias and reviewed private links she sent him 2 days before the grand jury's proceeding started. The implication of the latter assertion apparently is that Mello and Tully was spoon-fed maliciously edited clips by Miss Peters, which they then mindlessly regurgitated as grand jury exhibits. As Lieutenant Tully's affidavits demonstrate, that's not the case, and I don't trust him. Miss Peters was not part of the prosecution team. Sorry, it's a bad habit. But a source of information among many sources. The primary source of information was the victims of Kearney's broadcast, who complained about them to the Commonwealth. Although, to be sure, Peter may also have brought some of that information to Mello's or Tully's attention. In each instance, Tully went himself to the internet, viewed the alleged offending material, copied it if appropriate, and if presenting it to the grand jury, named it in a way that accurately identified its content, usually using Kearney's own words as contained in the excerpts, but not contained in his headlines or stream descriptions. The defendant's bold assertion that the Commonwealth employed Miss Peter to clip, edit, and rename Mr. Kearney's episode and then conceal the actual episode and their accurate information from a grand jury's consideration is an outrageous and irresponsible untruth. In but 2 instances, the Commonwealth of necessity did use the exact videos provided by Miss Peters. So the arguments stand. You did use it. Just because you didn't use it all the time, you still used it. So you can't do the, well, we never used it, only twice. Didn't she do a presentation saying she changed them? I think there is a text message that they got access to that said she changed them. So Tully edited it. Well, kinda. Tully just took the clips and then he changed the headline for them and said this was what they were called when Aidan went online with them. Shield and sword. Well, she's a big old sword. Shield. I don't think she's a good sword. That's not true. Krusty literally admitted to changing the names of all the videos and put it in a folder called Intent, and then Tully claimed the same thing. Yes, and the problem is there is a Discord link, I believe, or a Dropbox link out there that they have asked for that is gone. Which is another big problem. I don't know if it's going to come up in this. If they deleted whatever Krusty sent them, that's another Rule 14 violation because Krusty, is she allowed to just send them whatever and they can hide what they got from her? How do we know it wasn't Krusty? We now know that at least in two in at least two instances, they did use her material. How can they prove if they deleted the material they got for her that it's not that? They also used the correct names in the indictment as opposed to the inventive name used in the grand jury. That's another thing, because why did you need it there? You could just say, well, it's not the title of the show. We are referencing what show it is because Aidan always used the numerical, and then because it's a description of what content we are trying to prove, we have put that in brackets next to it. It's not what Aidan title the show. Make that clear, and then you could use it. Who has a thesaurus webpage bookmarked on speed dial? It was them. Yeah. Reasonable is to provoke laughter. Then just say it's laughable. This is my third language. Come on now. Because those videos were no longer up on the internet. So, again, allegedly because they had been removed. Yeah, if they're not up there, then they must have been removed, right? Both were wiretapping claims. One arose in connection with an alleged surreptitiously recording of Lindsay Kearney, which the defendant played on an internet broadcast. Wasn't it a presentation? The evidence was that the initial version was taken down and a second version substituted, into which Kearney edited for some other source an announcement that he was recording the conversation. Yeah, that is a claim that Krusty made. Kearney's testimony corroborated that Kearney never told her that the conversation was being recorded, i.e., the initial version, not the second, was genuine. The other Peter recording was introduced during the grand jury presentation involving Mr. Scanlon. That's the one that they didn't get. It wasn't the emails that were deleted. The links in the emails were broken because Krusty deleted the Google Drive folder. That's how it is. It was a Google Drive folder that she sent links to, and now Krusty has deleted them. So we don't know if Tully is lying. And I don't. Let me be honest. I don't trust one single person who works for the Commonwealth of Massachusetts. Not even the good guy cop who said the tail light wasn't broken. I have no trust left in the system in Massachusetts. From dog catcher to governor, you need to clean house. At trial, a defendant might well contest the authenticity of these or any recordings, but here the Commonwealth had a good faith basis for believing them to be accurate, based on the statements and testimony of the involved witnesses. Scanlon claimed that Kearney told him he wouldn't record their conversation. There was no impropriety in their introduction. Were the court to conclude otherwise, however, the proper remedy would be the dismissal of the resultant tainted indictments. That's unnecessary. The Kearney indictment is not before this court. It was never part of 2382 CR 00313, and in any case has been null prost for unrelated reasons by the Norfolk District Attorney's Office. Yeah, because you fucked up. Neither is a Scanlon indictment before this court, for as the defendant has complained repeatedly, the Commonwealth did not ask the grand jury to return one. As for the indictments actually before this court, to the extent she and Mr. Kearney shared a mutual loathing, and they clearly do, and to the extent to which she may desire to see him hurt, humiliated, and imprisoned, and she apparently does. The question for the court, and ultimately a jury, should a trial judge permit counsel to go down that particular road, is not the bias of any particular informant, but the reliability of the evidence. The Commonwealth's evidence before the grand jury consisted of videos indisputably made by Kearney documenting his own action and the testimony of his victims as to their knowledge of those actions and the impact they had on their life. It matters not a whit who informed the Commonwealth of any particular video's existence. What matters is the authenticity, Jesus Christ, of the evidence. For all the relentless characterizations of Tully's labeling of the video excerpts shown to the grand jury, an improper, intentionally misrepresented, out of context, cherry-picked snippet, prejudicially named, falsely named, misnamed, sliced and diced, cherry-picked, and out of context, and subterfuge tricked the grand jury. Nowhere does the defendant point to even a single word of Kearney's in any video clip that has been altered or modified by the Commonwealth. That's not what they're saying. They're saying you're misrepresenting his words because you're changing the headline to them. Oh, this is so dumb. He does not make those representations because he cannot. At the end of 30 pages of memorandum of law, 88 pages of meandering argument mislabeled as an affidavit, and a host of exhibits, the defendant's contentions amount to nothing more than sound and fury, signifying nothing. That's a song by Sousa. Thank you, Carla from Ohio, for becoming a member. It was the only one I could find where he wasn't in a judge robe. It's all out of context. Yeah, you don't have to change words. But if you clip at the right time, for instance, I often jokes that ladies should send me titlets in my DMs. If I am clipped and they put that in front of a grand jury, what would they think? If they don't get the part where saying it's a joke, then Baker wants titlets in his DMs. It's all about the editing in the clip. He's trying to portray it as what better row means is that we spliced videos. No, that's not what he's saying. He's saying you take it out of context, and by removing the context, you alter the meaning of it. The Commonwealth has provided the defendant with extensive discovery in this case, whatever the problems or flaws in its production of discovery, and there has been some. No, there's been a ton. They fall far short of requiring the draconian sanction of dismissal of the case. The Commonwealth promptly provided the defense with extensive discovery, as borne out by the items set forth in undersigned counsel's letter to Attorney Bradel on May 8, 2024. Also notable for the expression of undersigned's belief, naive in retrospect, that discovery was then almost complete. Yeah, because you didn't check up on it. And when you finally did, you were too dumb and too untechnical to figure out that you gave them tons of blank pages. You are an idiot. And the court should slap you all the way across your face. One, for your stupid language in this motion. And second, because you're a shitty prosecutor. The court should, take that out of context as well. I just threatened a judge. The court should take note of discovery itemized in that letter. The subsequent discovery letter of June 13th, and indeed the Commonwealth's filed and docketed response to the defendant's previous discovery motions in measuring the veracity of the defendant's claims that since Mr. Kearney's 2023 indictment, the Commonwealth has exhibited breathtaking indifference to its constitutional and statutory obligation to disclose evidence to the defense. Discovery has continued since that time, with the Commonwealth responding to defense requests and the defense in turn finding problems with the discovery provided, alleging missing discoveries, sometimes correctly so. So they are not alleging, they are pointing out that you are an idiot. Continuously generating new discovery requests. Yeah, because whenever they get discovery from you, they find out you lied. They didn't know about the Krusty connection until you gave them discovery that pointed to it. And now they're going to get the Lindsay Gattani files as well. And what does Lindsay Gattani have that they will then demand discovery produced? Because we know she talked a lot to Tully. And now she's not going to be on your team anymore. There's going to be more discovery requests coming in real soon. Continuously generating new discovery requests and demanding further explanation of discovery already provided. Some of the Commonwealth's problems has been logistical, which are not the defendant's fault. No, it's your fault, you idiot. But inform the realities of production. By way of background, the investigation into Kearney began about May or June of 23. Attorney Mello, a resident of Bristol County, was engaged as special prosecutor on or about September of 23. 6 months later, in March of 2024, the Norfolk District Attorneys recruited the undersigned to assist Mr. Mello with some legal research, writing, and similar tasks. Mello, however, proved to be gravely ill and has been physically unable to appear in court, requiring the undersigned effectively to assume full responsibility for the case. In point of fact, the undersigned has never been able to meet with Mr. Mello in person since undersigned counsel's entry of an appearance in any case against Mr. Kearney. While counsel has largely been able to obtain discovery material directly from the Norfolk District Attorney's Office, some of the necessary materials has been in Mr. Mello's possession, and his ongoing health problems and intermittent hospitalizations has retarded the process of acquiring it. Retarded as meaning slowing it down, not in meaning it's being stupid. To return to the previously mentioned May 8 discovery letter, the court will note that in addition to the discovery produced by undersigned counsel, in reference discovery previously provided by Tully, given Mello's illness, then hoped to be transitory, Tully was employed in the prosecutor's normal role of providing discovery. Another difficulty with discovery in this case has been the ongoing nature of the defendant's conduct towards the alleged victims and witnesses. To reiterate, just a few previously brought to the attention of court and others. What the hell? To reiterate, just a few previously brought to the attention of this court and others. There was his online hope that Lieutenant Tully would die horribly along with his wife and children, charmingly coupled with Kearney's self-comparison with Jesus. No, journalism, Jesus, you idiot. His nose to the window antics and accusations in the form of questions at the Albert's Pizza Shop captured by their security camera, which is illegal because it's wiretapping or something. No, it's a two-part state consent. His recent drive-by outside the Cape Cod home of a witness in the Kearney case. He did a drive-by? Aidan, you old gangster. His discourse as to whether or not an officer's wife was blue because Kearney speculated she gave her husband oral sex, and his repeated libels of Jennifer McCabe as a murderer. Talking about someone giving someone oral sex, how is that witness intimidation? What the hell is going on? What the hell is going on? There's 1,300 people here. Can any of you try and explain to me why the hell this is going on? This is... We're talking about the stupidest wife, and now we're talking about oral sex. Hey, I don't mind it. Well, I won't do it with Elizabeth Proctor, but I don't... Fellatio is okay with me. But why the hell is it as in a court filing as an ongoing harassment? Isn't it okay to make a joke about Proctor's wife giving him head, or Coco having 13 seconds in heaven, and that's why they couldn't hear the commotion outside of Fairview 34? Apparently, that's witness harassment. I'm sorry, but this is stupid. Because he's throwing everything at the wall, he has absolutely nothing. Well, sadly, the judge will most likely say, "Yeah, okay, you're right. They had a bite at the apple." These and a host of other antics, some relatively minor, some offensive but clearly legally protected speech. Talking about someone giving head is not legally protected speech. Why did you bring it into your motion? Prompt the victims to contact the district attorney's office, often by email, questioning whether action can be taken, whether the conduct is a bail violation, etc. Arguably, these constitute discoverable statements, although they say nothing whatsoever about the crimes with which the defendant is charged. Well, tell all of these idiots to stop contacting you then. To the extent they provide information on subsequent bad acts, the Commonwealth would be obligated to disclose such bad acts in any case before attempting to admit them at trial. If the statements are otherwise arguably discoverable, it is because they show a bias against Mr. Kearney that conceivably could be used to impeach him. but the reasons for any victim's bias are obvious from the very fact alleged supporting Kearney's charges. In that sense, discovery of the statements is entirely cumulative. This court should consider limiting discovery going forward to exclude victim statements that makes no factual reference to the underlying charged offenses and to prior or subsequently bad acts that the Commonwealth seeks to introduce at trial. Otherwise, there will be no end to it. Well, tell the idiots to stop calling. You did that to Lindsay Kearney. As it did with its attack on the grand jury presentation, the defense focuses much of its criticism on the Commonwealth's provision of discovery concerning Kathleen Peter, which it claims support its preposterous theory that she, Lindsay Kearney, Mr. Mello, Tully, and possibly others diabolically plotted to have Mr. Kearney's bail revoked by luring him into intimidating Mr. Kearney after they made her what Betterow described as a witness, taking care to put the term in scare quotes. Is that what it's called? We call them funny bunny, yes. Discovery provided by the Commonwealth shows that Kearney was indeed a witness, interviewed by the Popo with specific attention to what she knew about Kearney's ongoing communications with Karen Reid. After that interview, she received a summons to testify before the grand jury. Like so many other issues, the defendant has raised this one with the court before. The Commonwealth picks up the story by quoting a previous response. Why have it taken you so long? You're just copy-pasting. In abbreviated form, the Commonwealth summarized the evidence largely drawing on Ms. Kearney's testimony before the grand jury, supplemented by police reports and other evidentiary material, all of which has been provided in discovery to the defense. Ms. Kearney met the defendant in September 23 after viewing his blog and YouTube shows dealing with the Karen Reid case and ordering a t-shirt from his website. The relationship became intimate. By the beginning of December, the relationship had soured. Kearney came to the attention of Prosecutor Mello, who dispatched Tully and Special Assigned Private Investigator Nelson de Guvia, to interview her. As a result of that interview, the detectives returned to Kearney's home on December 22nd. Upon receiving the summons, Kearney feared that Kearney would think she had sought out the detectives and was trying to get him in some sort of trouble. She was afraid he would retaliate in some way. She called Kearney and sent him a picture of the summons. Hours of phone conversation and text communication ensued. Kearney became upset and accused Kearney of setting him up by passing along information to Kate Peters, a woman who he believed was adverse to his interest, and had provided the information to the police. The following day, December 23rd, acting against what he had told Kearney was his lawyer's advice, Kearney announced that he wanted to come by Kearney's apartment to discuss the summons. Kearney agreed. They met first at a business conference room in her apartment building. Upon arriving, all of this you have heard before. Kearney demanded that Kearney gave him the phone. She said he wanted to read any messages between her and Peters, as well as any messages with Tully and Proctor. Kearney refused. The defendant then threatened that his lawyer was going to have to destroy her on the stand, tear apart every piece of her life, embarrass her, bring up everything from her past. That's not a threat. That's just how they do. Stalling for time, Kearney went into the bathroom and telephoned Special Prosecutor Mello and spoke to him briefly. Mello called Tully, told him Kearney said that defendant was in her apartment and forwarded her call. Tully could not understand anything she said as the voice was muffled, inferably because Kearney did not want the defendant to overhear. After several minutes, the call ended, and at 10:48, Kearney sent Tully the following text messages. Ken said to call you, but I can't. He's knocking on the bathroom door. I have to go back out. Please don't text or call or tell Ken not to because he wants to see my phone. I'm deleting our calls and text right now. Do not respond until you hear from me, please. This is probably what I would go really hard on, and I'm not a lawyer, really hard on in the trial. So they were well aware that Aidan was at her apartment, breaking his restraining order. And she was so scared that Mello thought that Tully should be on the line. Why didn't Tully take his badge, his gun, and a fellow officer and go arrest Aidan Kearney? If he was in violation of his restraining order, which he was, which they later put him in prison for. Why didn't he already go there? Was it because you needed to go? Brian Healy, I don't know, but you can go watch the Glare. You don't have to be here. But thank you for informing us. Why didn't the police just show up and remove Aidan Kearney? Why did they do nothing? Because it was a setup. Panda Hawk, you are right. Cartoony emerged from the bathroom and unsuccessfully attempted to stall showing the defendant her phone. Terrified by the defendant's threats, Cartoony acquiesced and the two proceeded to her apartment. In the course of the conversation, the defendant instructed Cartoony to delete from her phone messages between the two of them. He said that I would not get in trouble if wanted to throw my phone in a river or delete any messages because with the summons, there was no order for preservation of evidence. Just go to an army base. So he said I could not get in trouble for removing any incriminating information from my phone about him. He said that he had confirmed this with his attorney, Tim Bradel. For the next several hours, the defendant went through Ms. Gattani's phone, reading through exchanges between Gattani and Kate Peter and taking notes. At the conclusion of this process, the defendant announced that he was very proud of her and was going to protect her. The reconciliation, such as it was, did not last long. Well, it did. Well, I don't know how long it lasted, but they did reconciliate. Later, while the defendant's attention was elsewhere, Cartoony ripped the pages of notes that he had taken from his notebooks, crumpled them, and shoved them down her shirt, and subsequently hid them under her mattress. Footnote omitted. I don't know what footnote they omitted. The defendant became aware that his notes were missing and demanded them back, accusing her of stealing his property. Eventually, he announced he was leaving and after some delay did so. Cartoony recounted these events the next day by telephone to Lieutenant Tully, who told her to call the Medfield police to report the incident. Tully perceived her to be hesitant. He called the Medfield police, reported what Cartoony had said, and asked them to follow up. Why didn't he intervene that night? Why did he leave her to be in danger by this horrible, horrible man pig called Aidan Gattani, who he knew had a restraining order and was not allowed to be at the premises? Why didn't big, brave Tully protect this woman? But it's not a setup, y'all. It's not a setup that she was in contact with both the prosecutor and the lieutenant, and none of them did anything to make sure Aidan got out of there. None of it. It's not a setup. Not a setup. The defendant has complained repeatedly that the phone text of that evening between Gattani and Tully was not included in the subsequent copy of the download of a phone provided to them by the Commonwealth. Undersigned counsel explained why that was in the case in his letter to Attorney Bradel on May 8th, telling him in pertinent part, if there's data missing, that is because it was missing when the phone came into the Commonwealth's possession, custody, and control, and thus we do not have it. The Commonwealth later secured the missing text with Tully by means of copying them from his cell phone. So they were there. Why didn't you do that to begin with, you idiot? And handed them to the counsel in open court during a hearing. Well, the second time. So in sum, the defense wished to tell the jury that the Commonwealth engaged in a plot with Kate Peter and Cartoony to make her a witness, then lured him to her apartment, provoked him to criminal conduct, then arrest him so his bail could be revoked. Yes, all of what I just read from your text is actually that. Well, you didn't mention Krusty, but she was the one giving the Mellows and Tully's numbers. So cunning were all the alleged plotters that Mrs. Cartoony studiously avoided any mention of their plot and its apparent progress when texting Tully. Nothing like it worked or he's here now. Arrest him. No, he's here now. She did say that. Why didn't Tully arrest him? Oddly, neither Tully or any other officer was outside Gattani's apartment waiting to bust in and arrest Kearney at the appropriate moment and not incidentally protect Gattani from any harm. Equally oddly, Gattani never reported the incident to the local police the following day. a lapse that prompted her alleged co-conspirator Tully to make the call. But why didn't he call 911 when this dangerous person who he knew multiple people has charges against for witness intimidation? Why didn't he act upon that? Is he a misogynist who hates women and just wanted Cartoony to be hurt that night? Or was it because he closed his eyes so he would have more evidence against Aidan the next day? And I didn't hear any of the call because the voices were muffled. It's kind of like, well, it was a butt dial. I don't believe that it went on for minutes. If someone is talking to me and I can't hear them for minutes, I'm hanging up. But we trust Tully completely. A copy of Lieutenant Tully's recorded call was provided to the defense in discovery. Truly, this defense theory is Lincoln-esque, at least in the sense that Lincoln has been quoted likely falsely of saying, you can fool all of the people of sometimes, but some of the people all of the time. So yes, obviously the defendant is correct that the Commonwealth thinks little of his theory. But indulging the defense contention that the Peter discovery was required, irrespective of the Commonwealth's subject belief in the reliability of the evidence, and further assuming arguendo that its conspiracy theory would be an admissible defense against the now dismissed Gitani indictments. How probative is it of the indictments before this court? Where Gitani is not a victim. The video evidence against the defendant was the product of his own hand. Kate Peter did not organize, participate in, or induce the defendant to organize, participate in, film, or broadcast the rolling rallies in which the defendant led a caravan of cars to the doorsteps of witnesses, haranguing them and intimidating them using a bullhorn. Oh my God, not a bullhorn. Have you ever seen a protest? Neither did Kate Peter compel the defendant to dox and defame witnesses and their family members. The defendant did this all of his own, and to what extent has the defendant been prejudiced by any delay in disclosure of Peter discovery, as he repeatedly assessed? If prejudiced at all, he has not shown it. Who has he doxed? The word doxed is very misunderstood. If your address is publicly available, i.e., remember the phone books, and someone says, "Yeah, I'm calling this number. That's Aidan's number." It's not doxing them if it's a publicly available information. I hate that everything is doxing by just saying, "Hey, Lindsay Gattani." That's you're doxing me. No, I'm not. I'm saying your name. Everyone knows your name. If you had a secret address and a secret phone number, and I said Lindsay Gattani, EBT Road 225, then I would be doxing you. But readily available information, like all of these witnesses who everyone knew where they live, is not doxing. It's so stupid. And yeah, you Zoomers, back in the day, a phone book wasn't something you had on your iPhones. It was an actual book you opened, and everyone's name was in it. It wasn't written by a serious person anyway. The sad thing is, maybe this judge, we don't know him yet. He might take it serious. They used a bullhorn when Garnet Petio was missing in Florida, harassing a victim. The defendant also has a related complaint concerning discovery concerning Ms. Peters, i.e. the Commonwealth's alleged failure to preserve exculpatory evidence. The Commonwealth provide in discovery various emails sent by Ms. Peters, some to Mello, some to Tully. Certain of those emails contain links, usually judging by label or contents, to various online broadcasts by the defendant. Tully's general practice, by no means exclusive to him, was not to access links in unsolicited emails sent from parties outside the NDA's office criminal justice network. But were they unsolicited? That is the crux of that argument. Mello, on the evidence of one response to a Peter email suggesting he was unable to access the content, apparently did so, at least on some occasions. Okay, again, you're admitting you did what they claim. The emails remain, but not all of them have links that are active. They have not been successfully accessed by undersigned counsel, and Tully and defense counsel also report that those links are dead. Why they are dead is wholly speculative. No, it's very clear it's because Kate Peters destroyed the evidence. Possibly the path expired of its own nature or was removed by the sender. It was destroyed by the sender, which is destruction of evidence. None of the emails at issue contained any warning to the recipient that the link was time limited, so most likely it was a willful deletion. The factual scenario raises some novel legal questions, e.g., what duty does an agent of the Commonwealth have to access an unsolicited link, conceivably exposing computer networks to malware? If the link, which is essentially an electronic path to another document, is not accessed, was the unaccessed document ever in the Commonwealth's actual possession? But Mello accessed them. As expressed in defense memorandum at 28, if the link is accessed, absent some notice that access may become unavailable in the future, thus the Commonwealth has an obligation to attempt to preserve the content of the link in some form as a precaution. Yes, that's the same reason why you download Ring videos that'll delete after 30 days. It's not that novel of a discussion. Does that obligation, if it exists at all, vary depending on the content of the link? For example, if someone sends an unsolicited email saying that a defendant looks a lot like Humphrey Bogart and attaches a link to Casablanca, is it sufficiently simply to save the email, or must the Commonwealth download and preserve a copy of Casablanca? Put 1 in the chat if you're a taxpayer in Massachusetts. These are the arguments because the state represents you against Aidan Kearney. These are the arguments they come up with. If someone says you look like Humphrey Bogart, should we download the entire movie? How can you put this on a piece of paper? How can you be this boomer? Because they didn't send you a video with a link saying Kearney looks like, I don't know. Who does Kearney look like? Jen McCabe's looked like Mr. Ed. Have we gene tested her? That's not what they sent you. They sent you a specific link saying, hey, look at this. Aidan is saying bad things about Jen McCabe in this link. The arguments are so stupid because it's not even apples and pears. It's fish and fowl. It's two different. For fuck's sake, this is dumb. You spent 5 extra days writing this, and you thought this was a good burn. What you got was a video snap. You probably didn't get the 4 hours that would be cruel and usual punishment. You got maybe 2 minutes of Aidan talking about how Jennifer McCabe looks like a horse that has been ridden way too often, way too wet, and maybe too much in the sun. You can download that shit. It's not that hard, and you should do that. Jesus Christ, it's stupid. Click the link, they might have access to your PC or phone. Well, Mello clicked the link. Tully was smart enough not to click it. Well, he claims so. And I trust Tully about as much as I trust Krusty. And that is a little bit less than a Taco Bell fart after I've been drinking. Does the content of Casablanca constitute part of the statement of the witness, or is the statement simply her own words or her own words and the fact of her attaching Casablanca, irrespective of the film's actual content? Where the link goes dead without any action by the Commonwealth, has the Commonwealth lost evidence or destroyed it? Finally, if someone forwards another email or a newspaper article without adding any content or alternatively adding neutral content as for your information, does the mere act of forwarding it constitute a discoverable statement? If the defense has pondered these issues, it gives the court no hint, proceeding immediately to the assumption that much of the undisclosed and now destroyed evidence was favorably digital material because it undermined Miss Peters' credibility, demonstrated her bias against Mr. Kearney, and supported the defense theory of a shoddy bad faith investigation. Given the difficult nature of the novel legal questions raised above, it's really not that novel, difficult legal questions. If Mello watched 1 second of one video, that entire video is Rule 14 material and should be turned over to the defense. If they didn't open it, of course, it's not in the possession of the Commonwealth. But I don't trust Tully didn't open all of them. I don't trust the video shown in front of the grand jury wasn't edited by Krusty along with the headlines. It's going to be interesting when they grill Krusty on the stand. Given the difficult nature of the novel legal questions raised above, the most useful line of analysis must be to assume arguendo that the Commonwealth had a duty to access the links and to take some measure beyond preserving the emails that contained them as a prophylactic against their possible becoming dead link. The court can then proceed to more familiar questions, i.e., was the evidence once available at the links favorable to the defense? If so, how damaging was its loss? And in light of the damage and the Commonwealth culpability, what should be remedied? Under Brady, even after the court is satisfied that the Commonwealth lost or destroyed evidence, the defendant is not entitled to relief unless and until he first established to this court's satisfaction a reasonable possibility based on concrete evidence rather than a fertile imagination that access to that evidence would have produced evidence favorable to his court. This could have proven that Kate Peters was the one editing the videos and not Tully, which would have then led to more questions about the credibility of Tully. Is that strong enough arguments for you? Commonwealth v. Neal, quoting State v. Michener. Here, the defense asserts that the missing evidence was favorable because it allegedly demonstrated bias by Ms. Peter and supported the defense theory that the shoddy bad faith investigation relied upon a civilian who despised Mr. Kearney and had a documented history of falsifying evidence against him. But none of that is true. Well, how will you prove that? Because you don't have it. Given, as the defense says, Peter's cooperation with the Commonwealth and her dislike of Kearney, it hardly seems probable that she sent links to evidence she thought exculpatory. What the hell? These are results for exculpatory. Search instead for exculpatory. What the hell? Nope, I don't want to go into that. Such documents are admissible if they meet the requirements exculpatory, self-favor exculpatory, and incriminating statements, and therefore the admissibility. So it's just exculpatory. Why is he writing these weird words? The reasonable and probable inference is that she sent links to Kearney's own broadcast, which she thought to be inculpatory and pertinent to existing or possible charges against him. Thus, the defendant wisely made no argument that the content of the missing links was exculpatory, but fiercely asserts that they demonstrate her bias against Kearney. The inference must then be that bias is demonstrated either by the content of the messages containing the links, but note that the defendant quotes none, or the mere fact that Peter was providing evidence to the Commonwealth, even if that evidence was probative of guilt. But there's nothing damning in any citizens assisting a police investigation by providing information. Rather, Miss Peters' lack of credibility, if such there is only demonstrated by the defense parade of her prior antagonistic statements against Kearney and what it terms as her documented history of falsifying evidence against him, for instance, her falsifying a federal document. None of this comes from the lost dead link evidence. If, unlike here, a defendant meets his threshold burden as set forth in Neal, the court then applies a balancing test to determine the appropriateness and extent of remedial action. The court must weigh the culpability of the Commonwealth, the materiality of the evidence, and the potential prejudice to the defendant. Commonwealth v. Villy. That test does not require the Commonwealth to prove good faith or earnest effort to preserve the evidence. Commonwealth v. Olevsky. Quoting Willie. However, this court need not proceed to that test, for no consideration of government culpability or materiality need occur unless the exculpatory nature of the evidence is shown. Commonwealth v. Williams. Should the court disagree, consider in the light least favorable to the Commonwealth, the analysis is as follows. Culpability of the Commonwealth. The Commonwealth delayed unduly in providing requested discovery of certain emails to the defendant. At some point, links in some of those emails went dead. Whether during the period of undue delay or earlier is unknown. The Commonwealth has not been shown to have been aware of the likelihoods of the links going dead, but it has been shown not to have engaged in any affirmative measure to counter such a possibility. At most, negligence, but no bad faith. Materiality of the evidence, none shown, though relevance to impeachment of Crosty is claimed. Prejudice to the defendant, little or none. The Betterow affidavit and defense memorandum overflow with purported examples of impeachment evidence the defense already has to introduce against Kate Peters. Should the trial judge allow such evidence against the witness, the Commonwealth has no need to call to prove its case under the pending counts of this indictment. At best, the missing evidence is entirely cumulative. In supporting the opposition view, the defendant relies on Commonwealth v. Woodward, which undercuts rather than assists his cause. There, the Commonwealth failed to preserve from an autopsy a missing piece of an infant's dura that was subject to a preservation order. The Supreme Judicial Court upheld the trial judge in holding that the loss of that evidence, surely more explicitly defined and potentially helpful to the defense that at issue here, did not justify dismissal of an indictment. The Woodward opinion then cited Commonwealth v. Sinelli for the proposition that absent egregious misconduct or at least a serious threat of prejudice, the remedy of dismissal infringes too severely on the public's interest in bringing guilty people to justice. If and only if the defendant has satisfied his threshold burden and the court then proceeds to consider a remedy based on the above analysis, the Commonwealth respectfully suggests that no remedy is required. But again, should the court disagree, surely any remedy would fall far short of dismissal. The defendant's motion to disqualify Mello need not be addressed. The issue is moot. Kearney indicate that one request is he never actually filed in his never actually filed motion was the disqualification of Special Protector Kenneth Mello. The defendant's memorandum of law, however, while commenting frequently on Mr. Mello's alleged failings, never addresses this request. There is a point 1, I think it is, arguing impairment of the grand jury process, and a point 2 arguing failure to properly disclose exculpatory evidence, but no point 3. Perhaps twixt the affidavit and the memo, the defense decided to abandon the argument, in which case the court need not rule on it. However, the issue is moot anyway. The copy of Judge Drulin's memorandum on the defendant's prior motion to disqualify Special Assistant District Attorney Mello, as forwarded to the office by the clerk, bears the docket number of both 2482 CR 00043, and 2882 CR 00313. In explaining his decision, Judge Ruling stated that ADA Mello, in receiving communication from a witness while the alleged crimes were being committed, made himself a potential witness in Kearney's case. Apparently, the judge's explanation was insufficiently damning for the defense, which seized the opportunity to recast it for this court as follows. Mr. Mello's involvement in this scheme, i.e., the alleged plot to frame Kearney for the witness intimidation and have his bail revoked, was so great that it resulted in the court disqualifying him from the prosecution of the 24 indictments, in which Ms. Kearney is the alleged victim. One may look long and hard at Judge Doolin's decision without seeing a statement even remotely suggesting what the defense avers under penalty of perjury. If he's a witness, he can't be a prosecutor. He made himself a potential witness, so that disqualifies him from the prosecution. Am I misunderstanding something? Well, my pleasure. By making himself a witness, he does disqualify himself. They are set to argue this on the 5th. Yes, this is for the 5th. Oh, this is even shittier than I thought. He waited until basically the day before holiday to file it, knowingly most take the Monday off, meaning defense will have less time to reply to this. Yeah, and for those of you who are new here, Jess did go to the same law school as Hank Brennan, so she has had the best legal education you can get. He was her professor in ethics, so she is a very ethical lawyer. But if Mello made himself a potential witness, he cannot be the prosecutor. Am I right? All he's saying is the defense is making it sound more mean and nefarious than it actually was. Yeah. Hey, you're right in most, in some of it, not all of it. You're right in some of it. Stop being so humble. We know that he was your ethics professor. The plain result is that Mr. Mello has already been disqualified. So you just said that you couldn't see it and they said it under the pains of perjury, but you then say he was disqualified. And the new motion to disqualify is superfluous. Fuck these long words. The Commonwealth has not sought to appeal Judge Doolin's decision during the early months of Mr. Mello's disability due to illness. The DA, Mr. Mello, and undersigned counsel hoped that he would soon recover sufficient health to play an active role in court proceedings. Well over a year has passed, and that hope has not been vindicated. Moreover, there is no likelihood that Mr. Mello will be capable of appearing in court in the coming year, neither as an advocate or in any other capacity. So he can't be a witness for the defense when they're going to ask him if he set up Aidan with the help of Krusty Panties and Lindsay Cartoony. That's just too bad, isn't it? Bowing to these harsh realities, the Norfolk County's district attorney and Mr. Mello has not entered into a renewal of his expired contract. Conclusion. For the reasons set forth by the Commonwealth, the defendant's motion to dismiss, as apparently incorporated in the Beddoe affidavit, should be denied, with the exception of the defendant's prayer to disqualify Attorney Mello, fuck these words, which the court should take no action on as the issue is moot. Respectfully submitted, Cosgrove. Yes. If I was Beddoe or Bradle, I would be losing my absolute shit right now. As the kid rightly pointed out, tomorrow is a day when no one works. You have, if you work Friday, Monday, Tuesday, Wednesday, Thursday, you now have 5 days to prepare based on this one. Most people probably didn't plan on working Friday because a lot of people take Black Friday off as well. They need to go fight over 70-inch TVs at Walmart. Monday, maybe someone would like a long weekend. They probably weren't going to do that because they have court on Friday. But effectively, they now have 4 days to read this shit, break it down, find the applicable laws that they want to use to argue it, and get ready for court. And at the same time, this giant sloth is begging the court to give him even more time because he can't prepare for anything. This man is incapable of doing his job. He is constantly going on and on and on and on about, well, the defense don't have any legs to stand on. Then he goes on to say, well, they kind of have a leg to stand on because this is true, this is true, this is true, but you can't really look at it that way. You have to look at it in a different way. Cutting something out of a live stream, again, going back, cutting out where I said, DM me some titlets. If you cut that out and you then labeled that Baker is always looking for titlets, then you're taking it out of the context where I say don't send me them. It's a joke. You are altering the message coming from it. So it's I don't believe he's that dumb. I believe he knows what creative editing is by just taking things out of context, even though he claims he don't know anything. They were involved with Krusty Panties, and well, they just need to destroy her credibility on the stand. That's all. No. Have you verified that everything she sent you was cromulent? And why didn't you disclose it? Why did you try and hide Krusty from them? That's the big question. With the tease. Well, she has no credibility anyway. No, she doesn't, because this woman has falsified federal documents. This woman is constantly in a courtroom. This woman is, we know her, very, very, very nasty. And her entire life mission is to put Aidan in prison. I had hoped that she would get a new pair of bracelet yesterday and be chucked into prison so she could pay for all the bad things she's done in her life. But she keeps skating. They keep protecting her. She has multiple restraining order violations. She should have had her bail revoked. And nothing happens to that manatee-looking thrall. Wonder why? Because we've seen what happened the last week, and I don't know if you're dumb enough to believe Lindsay and Aidan is back in bed together just because Kate is saying it. Lindsay apparently is in contact with Aidan's defense team, which is a whole different can of worms. If that is true, Lindsay could potentially become a material witness against Tully. If her and Tully have had conversations about get him to your house. She hasn't talked about that in her Substacks when she still did them. But then it's up to her credibility. That's going to be the problem with her. But if she has text, emails, discords, any kind of messages that the defense can use, I don't believe Aidan will ever forgive her for what she did. But use your enemy against your enemy so you don't have to fight that battle. And they lost Cartoony now. They can't lose Krusty. That's why they need to keep her happy. Because imagine if she got mad at the Commonwealth and she started singing about what the real deal with Mello and Tully was. why she gave Lindsay their number. Could you see that? I hope she gets put in the witness stand. And I hope that Mr. Betterow will metaphorically kick her ass so bad that her pants will be crusty again when she leaves, because he kicked her a whole new butthole. Again, take that out of context, taking out the part where I said metaphorically, and label it threatens crusty. They won't, because she wouldn't have one. I don't know. Receipts for what? What did I lose? Parts lover, thank you so much. She has receipts though. Who has receipts? No, they don't need to put Olivia into any of this. Lindsay Kearney is talking to the lawyers. Aidan has no contact. He has stated this multiple times. Still, people are dumb enough to sit there and say, well, I heard they're back in bed. Who told you? Krusty? Why do you believe Krusty? Well, because Aidan, people got mad at him back in September, and I really thought he was a bad guy. Now I'm a little mad at him as well, and I think he's that dumb. Stop listening to dumb people on the internet who tell you dumb things. Aidan has multiple times said, I don't talk to her. My lawyers talk to her, which he should, because everything from now on needs to be on the record. Because I won't trust her till she has been in the courtroom and said what she has to do. But the wording in this, the attitude in this is horrendous. I think it's unbecoming of a representative of a state. If anyone had given me a piece of paper like that back when I was in the city council, I would have thrown it back to them and said, go back and write it in a normal way. I think the judge is probably going to close his eyes and said, well, the best remedy for it is to go to trial, as they do every single time, because they don't want to take a position on anything. But I actually want to see this trial. This is a trial I could look forward to. Well, most of all, I want Aidan not to go to trial. Again, remember the defense fund. I want Aidan not to go to trial. But if it goes to trial, this is going to be fireworks. You're going to have Lindsay Kearney. You're going to have Grant Smith Ellis. You're going to have Krusty O'Pandies. You're going to have Brian Tully. You're going to have Michael Proctor. You're going to have Bukaki. All of the idiots from the village are going to be on the stand. That could be fun. That could be fun. Facts, I believe nothing that comes out of the crust. Why would you look, in my opinion, look at that? Why would you, in my opinion, look at that source? Well, the problem is some people are really mad at Aidan because something they thought at some point. So they are willing to believe everything bad they hear about him, no matter the source. And that's just dumb people who does that, because everyone should be a little bit smarter. But it's the internet. The internet is for stupid people. None of you wonderful people are on the internet because you are smart, lovely people who needs to go and have a wonderful pre-Thanksgiving evening. Tomorrow, as I do on most of those special days in America, where people might need a place to hang out because they're a little bit lonely if they're far away from the family. Maybe they are out on the roads making sure everyone else can get their turkey, gobble, gobble. Or maybe they just have too many people at their house, need to go into the bathroom, say, I'm just going to take 15 minutes on the throne and check into something. I will be doing a stream tomorrow. I have to go to the mechanic, so I don't know what time I'm going to be starting. It's going to be, I don't know. We're going to go for as many hours as I feel like. I have court Friday, so I can't go that late, but we're probably going to go for some time, maybe build some Lego. Maybe I think we're going to watch Alan Jackson from the last time he was in court with the car thing in California. and we're just going to hang out because some people get a little bit lonely and some people get a little bit overwhelmed. I'm not in America. I don't eat turkey tomorrow. So if you need somewhere to just come in, have your cozy little pot around with the baker and the chat, come back tomorrow and say, hey, how are you doing? How are this pectoral muscle? I can bounce it a bit. I did chest today. So if you need a place to hang out because your mother-in-law is really giving you crap about the cranberry sauce, or you are missing your father-in-law because he made the best mashed potatoes, come back tomorrow and we're going to give you a couple of hours of lighthearted entertainment to keep you trucking along if the days maybe need a little break from all your family or a break from not having your family. Can you all go have a wonderful day and see you later. I'm going to chuck you to the Clara and
I'm Jimmy. How y'all doing?
I know English is your second language, but you don't.
It's my third, but I'm still better at it than you. You are
The most